It's a significant responsibility. How we use that matters. Who and what we stand up for and what we stay silent about, what we monetize versus what we actually live matters. I have so much to say about the last 2 years of my life, but tonight is not the forum. What I will speak to separately is the feeling of being a woman who has a voice today.
Hi, besties. Blake Lively is co-opting a movement of women who bravely speak out and report what they experience in their workplace and speak out against situations that happen to them that are against the law. And as we've seen since this whole Me Too movement began, some men have been held responsible. Some men, very powerful men, have been put into prison. And many women were vindicated and received justice. And other women have co opted movements and used it for their benefit. If you want to believe that a woman cannot be a liar, look no further than Ghislaine Maxwell, who was attached to Jeffrey Epstein, one of the biggest liars, and a woman that participated in egregious crimes. It is unspeakable to consider that a woman could weaponize their femininity and laws that protect us to their advantage. But that appears to be what Blake Lively has done. And Blake Lively would like you to believe that because Wayfair put up a defense and filed a lawsuit, that this is what's called retaliation. And in the span of the last 8 months, she has filed no less than 3 separate motions for either sanctions and now attorney's fees, treble damages, and punitive damages, all with the same narrative, all with the same blustering, inflammatory language used to provoke a reaction in the press. Her legal team has been ruthless. In fact, she has employed lawyers at a notorious law firm who have represented the likes of Harvey Weinstein. Her lawyers have taken unusual steps and filed lawsuits that haven't really been based in anything other than an attempt to legitimize a stolen phone, which they claim is proof of a clandestine smear campaign to smear a woman who spoke up about what happened to her on the set of a movie. Now, one detail that I will say may have been a flaw and a mistake by Wayfair was using crisis PR and including crisis PR as a part of their strategy with their legal team. This has been a huge process in this case when it comes to discovery, because if you are a client of an attorney and you are seeking legal advice, you have privilege. You can speak to your attorney about anything that you're doing in your case. And anything that you tell your attorney and they tell you is privileged. But you relaying those messages to your PR agent isn't privileged. And while some people are so irritated by Judge Lyman because he keeps ruling in favor of Blake Lively with her motions to compel, it's a lesson for all of us to remind ourselves that just because we speak about lawyers or include a lawyer in a message doesn't mean we have attorney-client privilege. And including PR in your strategy for both sides is pretty wild if you think about it. This is a game of PR, but it's also a legal fight. And PR has taken the center stage for both sides. They're both guilty. Now, Blake Lively's motion for punitive damages and sanctions, treble damages and punitive and compensatory damages under a California law in a New York federal court, seeking relief and requesting that the judge find her as the prevailing defendant, the prevailing winner, a winner of these claims, and for the judge to then declare that he dismissed the case and she prevailed, not under litigation privilege, but rather under California Anti-SLAPP's 47.1. Anti-SLAPP is a lawsuit that allows you, it's a law that allows you to seek a dismissal of a case when someone files a lawsuit against you for the purpose to chill speech or retaliate. It's a method that many states have. Not every state has anti-SLAPP. Some have found them to be unconstitutional. States have had to reformat them throughout the years. Some have had them struck down. And the federal law has held most consistently that anti-SLAPP conflicts with federal rules of civil procedure. Now, some districts, like the District 9 in California, will allow California's anti-SLAPP into the federal court. New York's federal district, specifically the Second Circuit, which is where SDNY is located, has often held that anti-SLAPP is not allowed or permitted and violates the federal rules of civil procedure. They've already ruled in the past about California's anti-SLAPP laws and have denied the right for plaintiffs or for defendants to use these in order to seek relief. As well as in the federal courts, there's a rule, it's the American rule, that anybody that comes to court, whether it's a plaintiff or a defendant, will be forced to pay their own and incur their own legal fees. Blake Lively, who brought her case first, she was the first to file, found herself on the receiving end of a counterclaim. While initially filed as its own lawsuit, really what Wayfair's lawsuit was a counterclaim to her lawsuit. And Blake Lively has held rather consistently that any defense that the Wayfair parties place, whether it's via a statement into the press, whether it's something filing onto the docket, whether it is a website where they post their lawsuit, she has deemed all of these as retaliatory. Now, filing a lawsuit is not actually an adverse employment retaliation, and defending oneself based upon a lawsuit is also not retaliation. Once you enter the legal system, you no longer are held to employment retaliation. And most importantly, employers do have a right to defend themselves. And under the law, both state and federally, employers have a right to a proper investigation by the EEOC and state administrators. And in this case, Wayfair was denied the right by Lively, who did not file a charge with the EEOC and waived a investigation in the state of California. Now, Lively's most recent filing seems to be a retaliatory motion filed after Jed Wallace exposed her in his motion to dismiss for maybe bringing the case to the wrong state completely and systematically dismantling her claims under FEHA, which she admitted in her response to his motion to dismiss is generally not allowed to be used by out of state residents in out of state courts. The jurisdiction of FEHA is consistently and generally only held, and it can't be stretched out of the state of California. She's attempting to stretch it outside of the state of California by linking it to this clandestine smear campaign that she claims is in retaliation to her bringing claims forward to problems on the set. So, when he was exposing that California would be the proper forum for this lawsuit to have been filed, and she is trying to tie him into New York under New York jurisdiction, he exposed a flaw in her case where she's attempting to bring claims in multiple states using multiple state laws depending on what it is that she's seeking from the court. The vulnerability of her case being dismissed seems to have provoked this response today or yesterday, where she's seeking these 47.1 anti-SLAPP. I want all the money, give me everything, declare me the winner, give it all to me. And then also, please give me a hearing. I want my money now. This is the third time in as many months that she has used the same arguments about statements made by Brian Friedman in the press, or a website that was created, or a lawsuit that was filed. Now, under FEHA, An employer filing a lawsuit is actually not deemed a retaliatory employment retaliation. It has to impact her work. It has to be directly a negative consequence of what she experienced. So, a demotion, being fired, being isolated or removed from privileges, getting reprimanded, getting disciplined on the job. But by the time she claims this so quote unquote campaign happened, she was not an employee of Wayfair. And she was not with the Wayfair parties during the promotional tour. Given that Lively has now made this third motion, her first under Rule 11 sanctions, her second under Rule 3.6, and now under 47.1, demanding that this be found to be a retaliatory lawsuit, she's recycling the same talking points. And for many, it feels more like a PR strategy to continue her narrative in the press that Wayfair is the bad one that is continuing to do harm and cause harm against her. Specifically, she is insinuating rather directly, I guess it's not even an insinuation, she's accusing Wayfair and Brian Friedman of stoking online commentary of internet sleuths or independent journalists who have followed this case and have based their opinions based upon court filings or based upon deposition transcripts or based upon their own reactions to the way that Blake Lively chose to market the film or any of her other behaviors that they have found or deemed unsavory. Blake Lively was a controversial actress prior to being hired on It Ends With Us, with a long history of conflicts on sets, including a conflict with her director on the movie Savages with Oliver Stone. She also butt heads on her bomb of a movie, The Rhythm Section, which was made by the producers of the films The James Bond series. Blake Lively's extremely combative behavior on sets even was acknowledged by her in that she stated she walks onto sets and often will mislead producers about what her intentions are and instead demand and request authorship after she's only been hired as an actress, which is what Wayfair has claimed has happened to them. Because none of us were on the set and none of us know exactly what happened, none of us can say whether or not sexual harassment occurred. We can only go off based upon what her statements are, what her allegations are, and what the defense is of Wayfair. And then it's up to us to decide, do you believe her? Do you not believe her? And to date, we still don't have all of the evidence to make that decision, but most believe that the claims of sexual harassment are very flimsy and don't really meet the standard, along with the fact that she never filed an HR complaint. It kind of begs the question, was she really harassed? And then an agreement she made to remedy these issues she claimed to be experiences provided her a lot more control on the set and creative decisions, placing her closer to Baldoni. So, given that she is now continuing to request another amount of money, it tells me that she is just she's relentlessly interested in maintaining her PR front and center because many of the statements she's making in this lawsuit also will be picked up in headlines. The headline will be that Blake Lively accuses Wayfair of abusing and retaliating against her in the press by filing a baseless lawsuit. It helps continue to portray her as the victim publicly. Whether or not it's a true narrative, that's not up for you or I to decide. It's really up for a jury. And whether this will even get to a jury remains to be seen because a motion for summary judgment is likely to be filed by the Wayfair defendants. And what will remain of her case after the summary judgment is unclear. Right now, it seems at best many of her claims are on shaky ground. Jed Wallace exposes some of these vulnerabilities in her case. The reaction with the headlines of her not getting good headlines because of that is to retaliate. When she was accused of filing a fake subpoena and filing a fake lawsuit in the state of California through a Van Zandt action That was the first time Blake began her retaliation of sanctions. She filed her first motion for sanctions and safe harbor under that's when she's you're going to pay, I demand you withdraw, your claims are flimsy, get it out now. That was her first sanctions. Her second sanctions she filed after her deposition, where clearly something occurred in her deposition that she's not happy about. And some of the headlines that came out of her deposition and some of the news that came out of her deposition, where she admitted she couldn't actually tie Jed Wallace to anything. And she only knew of the retaliation that occurred to be a lawsuit that was filed against her, far different than the alleged smear campaign she claimed occurred. And while Lively continues to assert to the court this case is only about herself, her husband's name seems to show up a lot in court filings. And the damage to his reputation seems to be a pretty significant sticking point, so much so that it would appear that some of this may be orchestrated by Ryan Reynolds. All of this mere speculation. But while she continues to retaliate in ways through the press, Wayfair has found themselves on the receiving end of motions to compel that haven't always been the best for them. And yesterday, the judge also found that Case and Koslow, who work for the agency group and their privilege logs, not everything was privileged. So Blake does gain access to some of their communications. She's going to get access to one of the women's emails with her father about hiring an attorney for Melissa Nathan, which in the order we learned that Justin and Melissa at the time were considering filing a lawsuit against Blake. So this litigation issue wasn't just, if that's the case, retaliatory. It sounds like this was something that was brewing for a long time, which begs the question, was the lawsuit a retaliatory lawsuit, or were they already considering it in August? Regardless, other communications will not be allowed, specifically those that they had with attorneys. But coordinating between a PR company and a lawyer and having a lawyer in the conversation doesn't mean that there's actual privilege. And the judge said that they will be forced to hand over communications which are not privileged, which means even if Brian Friedman is on the communication, it doesn't really matter. Even if they are relaying a legal strategy, that doesn't make privilege. And his rulings are not biased. It's a fact. And one thing I will say, and an error that was routinely made by Wayfair, is that if you're going to use PR and legal together, trying to loop in an attorney to claim privilege is never going to work because the PR agent, the publicist, is not the target of the litigation. Justin was. And if Justin is relaying strategy, legal strategy to Melissa Nathan, that's up to him, but that's not privilege. So if he chooses to go outside of his legal team and get help with PR and have them help strategize, he can't expect everything to be privileged, nor can the members of TAG. I think the biggest lesson for everyone is that if you're going to sue, you sue. If you're going to just handle it as PR, then handle it as PR. Commingling the two together is where the problems are occurring and where some of the biggest mistakes have been made by Wayfair. And listen, I am not anti-Wayfair. I'm also not, against what they've done. I'm just saying that PR is PR. Legal is legal. Mixing the two is when everything gets confusing. I'm not a lawyer, but if I were in the position of what Justin and Jamie were facing, I probably would not have brought in crisis managers to deal with this fallout. I understand they had a massive budget and they had a film that was about to be released, but they also were dealing with this ongoing issue with Blake and Ryan. And understandably, they were under a lot of pressure. I think they needed better legal advice when everything was going on. And I think their passive approach of non-confrontation and often just bending and giving what was wanted to keep the peace put them in a position where they were always on the defense and made them easier targets to get steamrolled. Another issue that's kind of created this mess is the lawsuit that they did file, which was dismissed, had a lot of issues. And they roped in a lot of different people into a lawsuit, which didn't need to be in the lawsuit. And as much as I don't like Blake Lively, her attorneys do have points because there's lawsuits here where people are getting roped in and sued that have nothing to do with and were not in a contractual relationship with her. It's the same problem Blake's lawsuit has. She has no contractual relationship with Melissa Nathan. She has no contractual relationship with Jed Abel. She has no contractual relationship with Jed Wallace. None of those people are her employer. And so the same issue that Justin's lawsuit had, where people were getting taken out and, we don't have contracts with this person, so we can't be held responsible. She's going to see that in a summary judgment. Jed's already made clear, like, I'm not your employer. I'm a contractor for them. I was never in a contract with you. So both sides have put together lawsuits that may or may not be legally sound in a PR war, and neither side appears to be bending at this point. And as long as it keeps going on and keeps fighting, Blake is going to continue to retaliate as much as she can, because she, in my opinion, wants to control the public narrative that she's the victim. She also wants to reiterate over and over and over again and reinforce to the judge that she's the victim. But I will say that judges, in fairness, they do not like to have motions and sanctions filed where it looks like they're just repackaging the same Rule 11 sanctions motion and the 3.6 motion into now a 47.1. They're not ignorant or naive to the fact that what Blake is doing is just repackaging it into another grievance. And he's unlikely to rule on any of these, because if he were to, and he were to award sanctions prior to a trial, a jury could look at that and view that as though the judge is stating that what she has already told the court has been decided upon. So if he were to rule on 47.1 and say, yep, you're right, you had valid claims, that's not the appropriate stage right now for him to make that decision, because her claims haven't gone through the court to determine if they are valid. No decision has been made by the judge about the legal components of it and if it meets the criteria to qualify for sexual harassment, if it meets the criteria to qualify for retaliation, if she's taken all the steps to mitigate the impact and gone through and exhausted all her administrative sides, and if it meets the legal requirement under all of these definitions of the law. Until her case is decided, everything that she says is simply an allegation. So he can take her complaint as fact when he does a motion to dismiss, but he cannot take her complaint as fact in deciding that her claims are valid, if that makes sense, and that she is bringing a case that is solid and a banger and she's going to win. Because right now, it's all an allegation until a jury decides, or until the judge has to step in under a matter of law and use the law to decide. Nothing has been decided. And so he's not going to declare her the prevailing party, because then he would be stating that the grounds that she's brought this case are true. And so that would taint the jury. Well, you already said that these were valid. You already said that she wins. So I guess she wins. Judgments on costs and fee shifting are done after the trial. And if she were to lose and nothing is prevailed, all of these motions will then become exposed as being retaliatory PR moves, right? If she wins, she gets a hell of a lot of money, right? If she loses, it's exposed as a PR strategy. And right now, they are still waging this PR war. And right now, it just appears retaliatory. So tell me what your thoughts are in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed, and click the bell so you never miss a video. Thanks so much for watching. Bye, bestie.